Okay, we are continuing with our review of American courts and the federal court system. This graphic shows you the shape of the U.S. federal court system. At the top, you have the Supreme Court of the United States. Below that, you have circuit courts of appeals. There are 12 circuits, and that's where the appeals are heard that come from district courts. If you see on the bottom left-hand side, there are 94 district courts around the country, and they're divided into 12 circuits, and appeals go from district court to circuit court of appeals to the Supreme Court. The cases start at the district court level. There are 678 judgeships for 94 district courts. The Southern District alone of New York, alone has 28 judgeships. Almost all cases end at the district court level. We already covered jurisdiction. The most common basis for jurisdiction, for federal court jurisdiction, at least in 2010, was federal question. Why? Because federal courts are entitled to hear cases based on federal question. They kind of have to hear those cases. In diversity cases, there's often concurrent jurisdiction, meaning that those cases can be brought in state court. The federal courts of appeals are divided into circuits. The circuit courts hear appeals from the district courts. For example, the Ninth Circuit Court of Appeals hears appeals brought by the parties from district courts in the states within the Ninth Circuit. Some circuits are small. The First Circuit contains the New England states, except for Vermont and Connecticut, and has 6 judgeships. Other circuit courts are very big. The Ninth Circuit contains 29 judgeships. Let's just look at this last point here on this slide. The generally speaking, litigants in federal district courts have a right to appeal final judgments to an appellate court, except where the federal government is prosecuting a crime in federal court. If the accused is acquitted of a crime, they can't be you can't appeal that judgment. That's what's called double jeopardy, meaning you can't try somebody for the same crime twice. This graphic shows you it's a good visual of the courts of appeals. You see over here the Ninth Circuit. The Ninth Circuit contains all these states. Now, some of these states, like California, Washington, Oregon, are perceived to be left-leaning or liberal states. Some of these states, like Montana, Idaho, Arizona, maybe Alaska, are often more conservative. That's a very, very big circuit court of appeals, the Ninth Circuit. Look over here, you see the First Circuit, Massachusetts, Maine, New Hampshire, Puerto Rico, a very small circuit. The Fifth Circuit is also very big. The Fifth Circuit is where oftentimes challenges to the Affordable Care Act come through the courts there. The Supreme Court has had 9 justices since 1869. That number was set by Congress. Sometimes you hear rumors or you hear kind of rumblings that people want to change the number of justices on the Supreme Court. That would be very, very difficult to do, or at least very, very controversial to do, I should say. Question about whether or not it can be done by a simple majority in Congress, or whether you'd need a larger number of senators or of Congress people to do it. Hard to imagine, although you never know these days, frankly. The Supreme Court hears cases en banc. That means that the entire 9-judge panel hears cases. Then the chief judge assigns someone to write the majority opinion. There can be concurring opinions or dissents. Concurring opinions are where a justice may agree with the overall ruling but wants to put down their own reasons why they agree. Dissents are where a justice disagrees with the majority's ruling and wants their dissent to be memorialized in writing. Dissents don't have precedential power, but they can often be an indication of the thinking of some portion of the Supreme Court bench. Law clerks, tremendous power. Each justice has kind of a set of law clerks, maybe 4. And these law clerks help to do research and draft the first draft of opinions. They might screen cases. They do all kinds of things for the justices. And they have quite a bit of power, the same way a clerk at a courthouse has a lot of power. There was a novel called The 10th Justice, in which the premise of this novel about 20 years ago was that a law clerk, fresh out of Harvard or somewhere, was clerking for a Supreme Court justice, and by virtue of his job, had access to kind of advance notice of various rulings, either specifically or even things like if they knew which judge was drafting the opinion, that would give an indication of which way it was going to rule. And in the novel, this clerk was mixed up with some bad elements who were pressuring him to give them inside information about the rulings coming down so that they could sell stock or invest in things or blah, blah, blah. Anyway, it was a good book. It was not by John Grisham, by somebody else, but it was very, very good. The Supreme Court hears cases brought from the federal appellate courts and the state Supreme Courts, or the highest state courts. They only hear cases from state Supreme Courts if the issue contains, if the case contains an issue of federal law. A state Supreme Court's ruling on state law governs. If there's an issue of federal law, that can be appealed to the Supreme Court. The Supreme Court's jurisdiction is discretionary. That means that usually they get to choose what cases they want to hear. They don't have to hear your case. There are certain exceptions to it, but the real big deal is that you don't automatically get the right to have your case heard by the Supreme Court. In fact, usually you have to start by asking them to hear it by filing what's called a petition for a writ of certiorari. And that's basically a petition where you say, please, hey, Supreme Court, hear my case. Most of the time, the court denies these petitions because they don't contain an issue that's important enough to the Supreme Court. Interestingly, if 4 of the justices vote to hear a case, it's heard. So you don't have to get a majority of justices to hear your case. You only got to get 4 out of 9. And that's good because that lets, if there's a minority, if there's an ideological minority on the Supreme Court, they can still get the cases heard. And these hearings are public, and there's briefing, and there's media, and there's attention to them. So even though the case may not come out the way you want it to, a minority of justices has the right to vote to hear a case. The Supreme Court hears about 80 cases a term, and this is the current makeup of the Supreme Court. We've gone over this a little bit, but this is who it is. And one interesting thing about this list is that you look over here and you see Harvard Law, Yale Law, Yale Law, Harvard Law, Yale Law, Harvard Law, Harvard Law, Yale Law, and then Amy Coney Barrett here, who's the most recent appointee, who went to Notre Dame, which is interesting. We can discuss in the discussion board your thoughts about is it a good or a bad thing that 8 of the 9 justices went to Harvard or Yale? Are there pros and cons to that kind of education? Certainly there are pros. It's an elite education. And you certainly would want the people who are making the rulings about the constitutionality of certain laws to be educated and to be very smart. But maybe there are cons as well. Maybe there's a con that people engage in groupthink when they're all coming out of the same educational background. Maybe there's a con if they've all been reading the same educational materials, or have the same life experiences, or have other privileges. There's all kinds of questions about the makeup of the justices, and we'll talk about that in the discussion board. Let's keep on moving, though. Federal court administration, individual federal courts have chief judges. The chief judge, that is to say that, like, the district court in Springfield has a chief judge. And the chief judge assigns opinions and has administrative responsibility for their courts. Interestingly enough, you can't be a chief judge of a district court if you're over than 65. Contrast that with Supreme Court justices who are appointed for life. Now let's shift over to the state court system. Remember, the state courts are different than federal courts. Usually there are 4 major divisions within the state's courts. There are 2 at the trial level and 2 at the appellate level. At the trial court level, usually the trial courts are divided by jurisdiction. They can be general or limited jurisdiction, depending on the amount of money at stake. In this area, we call this district court or superior court. They hear cases worth different amounts. And that's just really a workload thing. They want to make sure that there's a division of workload so that more serious or more valuable cases, more not more important, but cases that have big price tags attached, don't get crowded out by very, very small disputes, small to the courts, not small to the parties. The courts can also be divided by subject matter. You can have probate or juvenile, domestic, housing court. Then you have intermediate appellate courts in 39 states. That is to say that after the trial courts, 39 states have an intermediate appellate court. Most cases don't go from trial court level to the appellate courts, but some do. And then above that, you have state Supreme Courts. These Supreme Courts will have between 5 and 9 judges, and most of those states hear the cases with the entire panel of judges. Again, most state Supreme Courts hear cases at their discretion, and they hear very, very few. Your textbook has an example of the contrast between the state court structures in Illinois and New York. Some of these state court structures are really, really complicated and they don't make any sense. Others are much more straightforward. One of the interesting things about state courts is that most trial courts are funded locally, although some states set aside money, and lack of funding can lead to a lack of resources. Another issue is how much money a judge might make. For example, an associate judge on the highest state court in Massachusetts might make, $170,000 a year. That's a lot of money. But when you contrast that with the amount of money being paid to junior associates, a first year out of law school, at a big law firm in Boston, they might make $190,000 a year. And if you're a partner at those law firms, you're making millions of dollars a year. So the question is, if you're a partner at a law firm, and you're in your 40s or 50s, and you're offered a judgeship, do you take it? You'd be taking an enormous pay cut, but you'd also be getting a lot of prestige and a lot of power and a very different environment. And so it's one of these things where it can be a challenge to attract highly qualified individuals to be judges, and the courts wrestle with that. Let's move on quickly because we don't have much time. One of the big questions is, how do you get to be a judge? And what are the priorities? Do you want judicial independence or political accountability? That is to say, do you want a judge who's afraid that they might not get elected if they have to run again? Or do you want a judge who's got the independence to say, I'm not worried about my popularity, I'm not worried about winning an election, I'm going to rule the way I believe? There are pros and cons to each. Should a judge have the freedom of law to apply the law as they see fit, or should they be accountable to the public? What method of selection results in the most competent judges? We're going to go over the methods of selection in a minute. Your textbook talks about something called the Missouri Plan, or merit selection, where state governors choose a new judge from a list of nominees provided by a commission, with the voters periodically having the opportunity to approve or disapprove a governor's choice. Let's go back to federal court judges. Federal court judges are nominated by the president and confirmed by the Senate. That's for everybody from Supreme Court judges to district court judges. There are ways for the Senate to block a president's nominee. They can vote against it. They can do nothing. They used to be able to use a hold to block an appointment. They used to be able to use the filibuster to block an appointment. That was lifted by Mitch McConnell, which allowed President Trump's nominees to be put on the Supreme Court. Then there are various ways to overcome a block sometimes. We've already gone over we haven't gone over, but if you look at the VoiceThread file below, we'll talk about the strange case of Merrick Garland, who's currently the Attorney General. But he was nominated to be a Supreme Court justice to replace Antonin Scalia, and his nomination was basically ignored. He didn't even get a hearing before the Senate Judiciary Committee. Important part about federal judges is that most of them hold their positions for life. They are not subject to election, and they're very, very rarely subject to a recall. They can choose when to retire, and they can choose when to retire during a president's term, which is important because let's say you're Stephen Breyer, the oldest judge on the Supreme Court. You might decide to retire during Biden's presidency if you're worried about the next president being not on the same page as you are ideologically. Let's stop here and move on.